Um, Thank you for joining today's class. Today's our last class, and I can't believe how time goes by so fast. Today we're going to talk about estate planning, but we also have a great, wonderful guest, Sarah Steckler. She works for Keenan Bean, and she's really the go-to person on long-term care and elder care planning. So I thought we're going to start the session with like her giving us a little introduction on the long-term care perspective, like how it's affecting all the people, all the baby boomers, like as they planning their retirement, and what they should be aware of, and how she can be there to help us. So I'm just gonna pass it over to Sarah. So thank you for coming, and thank you.
All right. Well, thank you, Bonnie, for inviting me. And hi to everyone out there. I can't see you, but I know you can see me. So if you have questions as I'm talking, please feel free to raise your hand, put the question in the chat, and I'll do my best to answer everything live. So I'm a trust and estates and elder law attorney with Keenan Bean in White Plains. And a part of my practice is dedicated to elder law. Elder law is the representation of older adults in their estate planning and in their healthcare needs. And a big part of that practice is, how do I pay for long-term care? Right now in New York State, the state of the law either is you pay out of your own pocket, which is self-finance, and for home care right now per hour, that's $25 to $27 an hour. And for nursing home care, that could be anywhere from $360 to $800 a day, depending upon the level of skilled care you need in a facility. So how does a normal family pay for that? Well, if someone plans in advance, maybe they purchased long-term care insurance. Certain older policies really have unlimited benefits, and those are terrific. But today, most of the policies only cover a portion of the need, as care has greatly increased in terms of the costs since those policies were underwritten. People still purchase long-term care policies, as well as New York State partnership policies, which is a special product that lets you keep your assets, use the policy, and apply for Medicaid. And people have also gotten very creative with how to finance long-term care using various estate planning techniques to qualify for Medicaid, so that their spouse or their kids are not impoverished by the cost of their care. So the state of Medicaid in New York State changed on April 2nd of this year, when Governor Cuomo passed his health law budget. And while the nursing home program remained relatively the same, the home care program is really seeing a lot of big changes that are making the rules much more similar to that of a nursing home application. So those rules, which were set to change on October 1st of this year, have been delayed due to the COVID-19 pandemic. And right now we're expecting the new rule implementation to happen April 1st, if not being further delayed depending upon where we are and New York State still being in a state of emergency. And the delay of the new implementation of the Medicaid rules change really gives people an extended period of time in which they can do estate planning to plan in advance should they have a long-term care health crisis necessitating the use of the Medicaid program to pay for a home health aide in the home or to pay for nursing home care. So currently, to apply for Medicaid in New York State to get a home health aide, the applicant cannot have more than $15,750 of non-retirement assets. So a non-retirement asset is anything that's not in an IRA, a 401k, a 403b, another kind of qualified account. So that would be your checking, your savings, your brokerage, bonds, annuities, any other holdings you may have, including real estate. So in order to get down to that threshold of $15,750, estate planning can be done. So with any kind of elder care work, You want to make sure that the client has a New York State durable power of attorney with statutory gift rider. So the full document with everything an elder law attorney can think of in that document to give the agent and the older adult maximum flexibility in terms of planning. And one of those important provisions is the provision to allow your agent, the person you're appointing to do work for you under the power of attorney, to establish and transfer assets into a trust that would then help qualify you for Medicaid. So we use a lot of irrevocable trusts to shelter those non-retirement assets to bring someone down to the Medicaid asset level of $15,750. There are other techniques that can also be used because Medicaid doesn't penalize transferring assets to your spouse or to a disabled child who's certified disabled. And that disability certification is by the government. It's not that someone is disabled because of work or getting workers' comp or has had an accident. They have an official disability determination. For Medicaid, also someone is limited to the amount of income they're allowed to have. Currently, they're allowed to have a net $895 in income, which most individuals who have worked have more than. So how do we bring someone down to that level of income? We set up what's called a pooled trust for disabled adults who are 65 years of age and older. There are many trust companies in New York State, also in other states, that have these sorts of pooled trusts. And an application is submitted, and then we work with the trust to have the person's net income over $895 moved into this pooled account on a monthly basis through wire transfer. So once we've made the person eligible for Medicaid on both the asset side as well as the income side, then we can apply for Medicaid, and a person can work towards getting the services they need for long-term care. And it's a lot of work. It's a process for the family. It's a process for the attorney's office. And there's a lot of details that go into it, which can be somewhat overwhelming. But like anything that's important in one's life, the work is worth the end result, which is getting the care that's needed. Another part of this sort of long-term care planning is calculating the burn rate of someone's assets. So seeing how long we can stretch someone's assets through their retirement and to pay for care if Medicaid is not warranted or the family doesn't want to utilize that program. So we do a lot of math in Excel and we figure out how long someone's assets will last in the most tax efficient way possible. And we also talk about certain healthcare forms, which I know we're going to talk more about later in this workshop. We make sure that someone has a healthcare proxy with a HIPAA release or a separate HIPAA form. New York State now has their own HIPAA form, which is Form 960, which can be found on the Unified Court Systems website, as well as they have forms that really pertain more to people towards end of life. One of those forms is called a MOLST form, which stands for Medical Orders for Life-Sustaining Treatment. It is a hot pink form which contains all sorts of orders as to what the person would choose in an end-of-life situation. Do not resuscitate, do not intubate, so no breathing tube, no antibiotics, do not feed. There's a separate form for people who have cognitive impairment than who can self-direct, meaning speaking and giving instructions. The form doesn't have to be hot pink to be valid, but most of them are hot pink or pulsar pink because the paramedics, EMS are trained to look for that on the refrigerator in the event that 911 is called. The other form, which New York State has, is called a non-hospital DNR, which, like the MOLST, can be found on the New York State Department of Health's website. And a non-hospital DNR is exactly that. The only medical order on that form is do not resuscitate. And we get the question a lot, well, what happens if I have both? And the paramedics, if the decisions on the forms are different, if they're in conflict, they'll use the form with the most updated date. So whichever one has the freshest date. And those are two really important forms in an end of life circumstance, especially when someone's at home before hospice is involved. So there's a lot of components to planning for long-term care situations, from paying for the care, saving for the care before you need the care, utilizing government benefits, and making sure that you have a solid estate plan that allows you to take advantage of certain benefits that New York State provides. And one publication that my office, in connection with a group called the Senior Law Day Collaborative, publishes every year is called the Elder Law Q&A. And it can be found in both English and in Spanish with all of the forms I mentioned at www.seniorlawday.info. And it's a clickable PDF. And I like to jokingly say it's late bedtime reading for those who have long-term care questions. And it covers everything from Medicare, which is health insurance, to due to your age, Medicaid, which is an entitlement program. It's health insurance based upon your asset level, as well as all of the various medical forms and questions that we've come up with through the years. So, Bonnie, do you have other things you want me to cover? I know there are other speakers. Do we have questions? There's a lot of details.
I think so too. I think what probably we should start, because I think like what you said, I'm going to cover quite a lot that you talked about, but on a like higher level. Maybe when everybody, when you got questions, just stop me and do the chat, and then we'll pause and you can ask questions, or we can run through it really fast and then we can have a Q&A, because it's probably good to have an overview first, because there's a lot to cover. So let me just kind of move on. So thank you, Sarah. So anybody who wants to contact Sarah later on for questions or whatever, her contact information is there. And I think I had the PDF that Sarah talked about, so I'm happy to email to everybody. It's really very good nighttime reading. I think it's 80 pages long. It's really, really long.
Right, and the most important takeaway is to plan in advance, because a failure to plan is a plan to fail. So take the time, review your assets, look at what you may need, look at what your family is going through, and try to formulate a plan that's going to grow with you. It's not set it and forget it. Just like investing and working with your advisor, you want to have that constant dialogue and to review and revisit it, so that when you do get there, you have something that you can enact and that really is tailored and works for you.
All right, thank you. Thank you, Sarah. All right, so let's just move along. Okay, so let me just go over the agenda today. So Sarah just gave us a little introduction on long-term care and elder care. How do you plan ahead? How do you manage the costs? And there's a lot of forms to fill out, and she's going to share the PDF, which I'll send it out to you, and then you can review at your leisure. So we're going to go over some of the main things, like will. What is a will? What's a trust? Power of attorney, healthcare directives, and the titling of assets. And then, when you plan for the estate, a lot of times, what kind of estate tax do I have to pay? Gift tax, GST tax, state tax, inheritance tax, all the tax angle. And then we'll talk a little bit about estate planning for married couples, and then some advanced wealth transfer strategies, but I will be very skimpy here because it's very, very advanced. So I just want to tell you a few, some of the main ideas that people typically mention. So let's go. All right, so I like to start with a trivia question. So let me ask you, we really call this is the greatest wealth transfer in history. So how much asset are we looking to transfer in the next 25 years? And if you were to guess, how much assets do baby boomers hold? Any suggestion? Any idea? Now I will just tell you the answer because. Okay.
Yeah. No, I would have guessed like $1 million and a half.
No, 68 trillion total.
Oh, the whole thing. I'm doing per person.
68 trillion will be transferred the next 25 years. So a lot of money. So estate planning is key. Okay, you want to make sure that the money goes to the people that you want to go to instead of to the government. And the baby boomers own 30 to 40 trillion. Okay, so it's like a big part is like the people who are about to retire. And the youngest baby boomer is about 55 years old. Oldest baby about 70. Our next question is, what percent of the population has a will in the US? It's low, okay? When I saw it, I said, what? Any guess?
25%.
A little bit better than that. Yeah, it's 40%. So most of the people, less than half of people have it. And a lot, the reason is that, hey, look, sorry, I don't have the time. I know it's important, but I don't have the time. So they think that they should have it, but only 40% actually have it. So of course, like people a bit older, more people will have it, but like you don't want to wait until the last minute. So you really should start planning, like what Sarah says. The sooner you plan, the better it is. And
Ronnie, we had a question that came in regarding what I was speaking about, and really the Medicaid details that I was talking about for the student that's in Arizona pertains specifically to New York, because Medicaid is funded in each state through a combination of federal block grants and then state monies. So each state has different rules as it pertains to Medicaid, but regarding long-term care insurance, regarding wills and trusts, and anything that is federal law or federal tax, that applies to everybody, no matter what state they're on. And every state has different state estate tax and or inheritance tax rules. And those sorts of rules would be specific to where the person who died lived. So there's a combination here.
yep.
So it's very important to filter.
Thank you, Sarah.
Okay. All right.
Wow.
Any other questions? All right, so I will move on. I want to talk a little bit about will. Just like a lot of people don't have a will. I mean, like Michael Jackson doesn't have one, Aretha Franklin, and Prince doesn't have one. And these are the people with lots of money. So if you don't have a will, what happened? Okay, so so what does the will accomplish? Okay, it will help you, you appoint an executor, and then it will help you decide how you want to divvy your assets, and then who you want to give it to, and when you want to give it to. So you make most of the decision. You make the decisions. And if you don't have a will, and if you pass away, then the state will decide. And based upon where the person who passed away, where they reside. So if it's Minneapolis, Minnesota, so that state will decide. So let's just take a look, use this as example, what happened to Prince's estate. He died in the year 2016, okay? And the final ruling didn't happen until 3 years later. So his estate kind of like dwindled down from $300 to $200 million, still a lot of money. And the state's residence, his state of residence is Minnesota. So we go by the Minnesota rules. And he's not married, he doesn't have a kid. His parents also passed away. So the money is actually going to his siblings. And of course, they're gonna fight over all that money. And the state is split between 6 half siblings. His brother passed away, Alfred Jackson passed away. So 1/6 of the whatever was supposed to go out to him. And his sister, another sibling, has to sell off a lot of the estate that was due to her in order to cover legal bills. So if Prince had planned a little bit better, it doesn't have to take 3 years to settle the estate. And a lot of money is like, went to cover legal bills instead of going to people that deserve it and should get it. I thought, how complex it is. So I went on and take a look at the Minnesota intestate succession rules. And here, okay, so depending on whether you're a spouse, whether you have a kid or no kid, it all depends. All right, so if you married, no children, goes to you. With a kid, goes to you, okay? And then because in his instance, he's not married, he doesn't have any children, his parents passed away, so it doesn't go to the parents, so he goes here, as it goes here. So if no parents, the entire estate goes to the siblings. So maybe he doesn't want to give it to his siblings. Maybe, you know, he's living with somebody that, you know, for a long time care for him. He's really in love with that person, but because that person, you know, he's not married to that person won't get anything, and he got no kids. So, you know, that's what it is. So it's kind of sad if he wants to take care of somebody and he didn't make any planning, then the state will decide, and it'll be maybe the money will be given to somebody that he doesn't really care so much about, or like there'll be other people that would not be on the list that he wants it to go, the money to go. So the next slide is about the reason for why you should have an estate plan. Keep assets out of probate. So if you have a will, at least like you know where it goes, but it will still go to the court to decide, to finalize where the money will go. To protect assets from creditor and divorce, and direct assets to professional management when you become incapacitated. So Sarah talked a little bit about that. And make sure the assets go to the right hand, the people that you love, you know, maybe somebody, you know, a kid, or, you know, it doesn't have to have like a special family relationship, but somebody that you want to help, a friend or something. And then that you don't want people to be fighting over your estate, and it costs a lot of money, a lot of time delays, and a lot of like ill will. So you want to minimize the potential conflict among beneficiaries. And then Medicare planning, you know, it's also a big part of estate planning. Here we have a video. I don't know if we want to watch it because we don't have a lot of time. Maybe we'll save it to the end, and then let's just go over, you know, the basic estate planning. What are the components? I put this chart together. So Sarah, you know, tell me, you know, if I'm missing out anything, and I just go, wow. You know, it's like pretty complex. So you can have the will and so you decide, you write down who you want to give it to, the money to, and then trust, if like will, like you pass the money after you die, you pass away. The trust, you can do it now. And then there are two types of trust, revocable and irrevocable. And then health directives. So healthcare proxy, HIPAA, you know, all this, living will. We're going to cover that a little bit later. And then when you're incapacitated, you know, you want to get somebody to help you make decisions, financial decisions, investment decisions, and all that. So there are power of attorneys, general, durable, and specific power of attorney. And then titling of assets. Okay, so I mean, besides all that, you know, if you have 401k, you know, it goes to the beneficiary here. Okay, annuity. I mean, there's like a special beneficiary form that you have to fill out. So that's predestinated. So if you fill it out, you know, if you pass away, whoever's going to get the money, it's already predestinated. You already decided. And then when you own real estate, okay, so how's the real estate being held? That's, you know, that's pretty complex. So it depends on whether it's joint tenant with right of survivorship, I'm not going to go too much into detail because later on I'm going to cover it. And then power of will. So whatever hasn't been decided, like before you pass away, that's left out, any of this has been left out, will go to a trust through a power of will. So there's quite a lot for you to think about. So your health, okay, and when you can't really decide to manage your financial assets properly, the power of attorney, and then all your assets, you know, like how is it being named right now? Okay, so a lot of people, when they get married, they divorce or whatever, you know, like are they being like titled properly? So you need to make sure that there are no disputes later on. So all that matters. Okay. And here we're going to talk about some basic planning documents. Start with a will. Okay, who needs a will? I mean, anybody. You know, you have to be 18 and above. You have to have some assets, so you own investment properties or stocks, bonds, whatever. You know, any assets that go under your name. You know. Okay, so when you pass, like, where is it going to go? Maybe you have dependents, so you need to know like who's going to take care of your dependents. Maybe you want somebody to help you take care of your parents, your children, or maybe even your spouse. So like you write all this down, but you don't want to write it down when a lot of times, like when you're too sick, you can't really think. And when you're too healthy, you're too busy. So it's always good to at least like start thinking about it. You know, I know it's not, you don't have to get it done today, tomorrow, or next week, but it's always good knowing that. I mean, if you know somebody who doesn't have a will and they had to go through all this, so much money, so much time wasted, and still doesn't get the desired result. So you might want to, if you want to take, you really care about somebody, you should start thinking about, you know, how to plan it out.
And also, Bonnie, there are a lot of online services that offer wills and trusts and other vehicles, but I cannot recommend any of them. And in fact, I've had a lot of problems in litigation with people who've used online services like LegalZoom, as well as
I'm going to talk about that.
and so wherever you may be, reach out to a local professional who knows the law in your state. Sit down with that person, have a phone call, have a consultation, and to work with someone face to face or virtually face to face rather than a computer or a ghostwriter who may be preparing documents that are or right for you, but they may not be.
Thank you, Sarah. As a matter of fact, you know, but I think it's also, those websites are probably still pretty good for you to learn some information. You might not want to go with it, but I think they have a lot of free resources. So free stuff is okay. All right, so this is like a list of different wills. You don't have to know them all, but I just thought it's pretty interesting to just mention a few. Simple wills will most likely get what needs to be done at a much lower cost. And then I didn't know there's joint wills that you can do one with your spouse. And it's irrevocable when one passes.
Not every state permits that anymore.
All right, okay, not every state permits it. And then you can do it like handwritten. Okay, that's very not common. And a spoken will. Okay, but not all states recognize it. Oh, here's a mistake. Transfer. Anyway, so and then so there are different types of wills. So depending on like at where you are at, you know, but probably if you want to and enjoy wills, and then also that you can do electronic wills. But Sarah says like the best if you talk to somebody, because like if you talk to a professional, they probably know, they've seen so many things like people went through, and then if you just think about yourself, you might not have all that experience. So it's always good, like after you've done it, show it to somebody. Say, oh, you forgot about this, you forgot about that. Oh yeah, really? Okay. So before it happens, somebody will give you some ideas how you can make it a little bit better, smooth out the process a little bit. And then a valid will is somebody who is at least 18 years old, and then has at least one executor, and must be signed in front of 2 witnesses. But there's no requirement that this could be recorded or filed with any governmental agency. And here's the step for creating the will. Like I think what Sarah says, okay, take inventory of your assets and your liabilities. So what do you owe? And then, you know, who are you gonna give it to? So choose your beneficiary. And then you have young kids or like whatever, you know, you need to select an executor when you're gone. Who's gonna help you do all this work, you know, file all those paperwork, you know, talk to the people that you want to give out the money, you know, do all this extra work. So like somebody.
But the good news is the executor gets paid, they get commissions. So they may be doing it out of the goodness of their heart, but they also can collect a statutory commission. So you can feel a little bit better about having that person do the work for you.
I was actually thinking just like somebody, a family member that I really trust with some good financial background. And then you just sign and notarize your will, and be explicit how you pass your assets down, and who you want to appoint for your guardian for your children if you got kids, and put it in a very safe, sign and notarize, put it in a very safe place. And when your life situation changes, make sure that you update your will. So if you've done your will 20 years ago, probably is not very relevant. So you might want to pull it out and update your will.
And by update your will, redo your will. Don't write on the document because those changes may not be acceptable to a court.
Okay, thank you. All right, so let's say you don't want the will, so what do? Okay, so you can destroy it, you can add a supplement, or you could just redo it, like with what Sarah says, like.
Well, no, the codicil is perfect too, but there are people who take a pen to their document and then they think that
Scratch it
those
out.
changes are valid, but you can absolutely do a codicil or redo it. Both of those are perfectly legal choices.
Acceptable. All right. What is probate? Is a legal process administered through the state courts. Oh, shucks. That helps in the orderly distribution of deceased assets. It legalizes it. And the probate process involves collecting decedent's assets, liquidating liabilities, paying out necessary taxes, and distributing the property to heirs. So basically everything, you know, making sure that the assets get paid out, the liabilities get paid out, the taxes get paid out, and whoever deserves the money will go to the person who needs the money, who deserves the money that you want the money to go to, will finally get the money. And then reasons to avoid probate: very costly, time delays, and then we talk about loss of control. You want the money to go to where you want to go, so you want some control, and loss of privacy. Sometimes you might not want people to know like how much money you got and who you're gonna give it to, and then you don't want people just to know anything about your personal life, you know, even though you're gone. And intestate means that you die without the valid will. And we talk about like all these like famous people. I mean, obviously it's not a money issue, but just they don't want to think about it. And when it happened, and it's too late. And die intestate means like, okay, the state is going to take over. And we did an example of Prince. So, and if you can't find, no family can be found, then the money will go to the state. How do you avoid probate? I think the best way to think about it is like making sure that all the assets are properly titled to the beneficiaries that you want to go to. So if it's a joint ownership of property, you know, these are the different ways of holding it. Community property with rights of survivorship. Tenancy in common. So if let's say, you know, there are 3 tenants in common. If one passed away, it doesn't go to the other tenant, it goes to the heir of the person who passed away. And then these are just making sure that like if you have investment, saving bonds or whatever, making sure that you have beneficiary properly designated as a form that you need to fill out. So when something happened, the account will go to the right person. And these we talked about, like anytime when you buy life insurance, when you have annuities or 401k plans, there's a beneficiary form that you're required to fill it out. So that will simplify things. So, you know, that's already like have a title in case you pass away, where the money is going to go to. And if you do not fill out that form, it takes forever for the money to distribute. So make sure that you do have a copy. A lot of times, these like, you know, probably are filed online now. I mean, before it's like a payable copy. And now I know that a lot of these like 401k beneficiary lists, beneficiary forms are filed online. So it's much easier now. And probably we talked about. Ready? So we talked about will, and this is trust. So there are 2 different types of trust: revocable trust and irrevocable trust. And why do you want to trust? Because during lifetime, before you pass away, you can actually make decisions while you're alive, where you want the money to go. If you have to go for probate, a lot of times some of the assets is frozen, so you can't even use it to pay for bills that you need to pay. And we talk about avoiding probate, so you want to make a decision where you want the money to go. And privacy, you don't want people to know. You don't want people to find out where the money is going, how much money you've got. I mean, so you just want to keep it kind of private. So these are the reasons why you want to have a trust. So first we talk about revocable trust or living trust. So the grantor will name himself as the trustee. So so you're the grantor, okay? So you're the trustee. So you will supervise the management, the distribution of the assets during your lifetime, okay? And then while you're alive, you control the assets, but when you pass away, it goes to the beneficiary, it goes to the trust, and the trust beneficiary. But during your lifetime, you can use the assets any way you want because you took control. You take control. So it's a good way that, like, while you're alive, you can control the assets, and you know how to use the assets. You can use it the way you want. But when you pass away, you already predesignated where you want the money to go. And because it's revocable, you can always change your mind who you want to give the money to. For irrevocable trust, then it's just the opposite. Once you give it away, it's irrevocable. And because it's irrevocable, the trust it's taken off from your estate. So that can help in reducing how much estate tax you have to pay. And normally you designate somebody to help you manage the irrevocable trust. And then the trustee will have discretionary power in how to make the distributions for the beneficiary. So the big difference is one, you can change the beneficiary or you can change the terms, and the other one you can't. And here, this is like what Sarah talked about. Okay, it's LegalZoom, and there's another one called Trust and Will. Just check it out because they have interesting stuff to talk about estate and will, just like for your general learning. And it's very, very cheap. The will is only $89, okay, and the trust is $399. I think if you engage a lawyer, it's probably more like $1,000, right? Am I right, Sarah?
It depends on the state you're in, but it's much more. But from my experience, I've never had a positive experience with LegalZoom. I've only had litigation because they don't keep your documents. They keep unsigned copies of it, and they have all these shell corporations like UDeed, which doesn't exist, which retitle your property, and then it's a defunct LLC. You can't find it. So from a professional perspective, I'm very much adverse to it from the experiences I have. But there is a lot of good information online, but you also have to very carefully screen because some of it's old, some of it doesn't pertain to you, and then some of it's good in between. So it's always good to ask questions, and a lot of the times with a law firm, you can ask questions and have that initial conversation without having to retain and move forward. So that's also a great resource in a local community.
Okay, all right. So next is we're going to talk about power of attorney. So you give somebody, an agent, the right to execute legal or business transactions. So there are different types of power of attorney. The specific power of attorney for like a specific job or task. General power of attorney, so for all matters, for like almost everything. Limited power of attorney for like special, so limited power instead of everything. And it can
like a real estate closing.
For the real estate closing. Yeah, that's right. Okay, and power of attorney formats can be springing. So I mean, it just pops up for when a certain instance happened and it's springing up, it's spring up. And durable power of attorney. So when you become incapacitated, then that's a durable power of attorney, and non-durable. So all right. So in the medical and financial, and all the power of attorneys will terminate when you pass away. So let's talk about titling of assets. Okay, joint tenants with rights of survivorship. So what does that mean? Okay, so when one of the partner or spouse pass away, the other will receive all the money or the property. So basically, it goes to the other person if one passes away. Tenancy by entirety is basically kind of the same. So you're talking about a spouse, two people, And they basically have equal undivided interest in property. So if one passes away, it goes to the other person. Community property rights of survivorship. So let's say you're in California, where it's a community state. So it's jointly owned by both spouses. So if one passes away, the other, so half, the one person get half, the other person get half, so that half will pass to the other spouse. Tenancy common, so it's just like, like a friend, okay? So this is mean when that person, your friend passed away, it doesn't go to you, it goes to the heir of your friend. So those are the different meanings for these terms. And here are the Advanced Healthcare Directive. Living will, I think Sarah talked about this already. Okay, so this is basically you want to determine how you want to be treated, how the medical decisions should be made when you incapacitated. And then it requires 2 physicians to confirm that you are incapacitated. And these treatments such as dialysis, whether you need ventilators, do not resuscitate me, and tube feedings, all this organ donation, and all this. So it's pretty detailed. As a matter of fact, I have some forms that I will show you some of these forms that Sarah mentioned about. Durable power of attorney. So when you are incapacitated, you want to name somebody. So when something happened to me, maybe I want to name my husband, or you don't trust your husband because he's too nice, or maybe you want somebody to really be more firm, so maybe my sister's better, so I'm going to name my sister to deal with my doctor. And then the HIPAA authorization form is a document that will allow you to share all your health care information. That's like very confidential, very private. So you want to pre-designate what you want to share, who you want to share with, okay? And then the POLST is a portable physician order form. So that's also very interesting. So if I don't know what to share, maybe my physician, my doctor knows what to share. So, so that's another form to help describe what type of life-sustaining treatment you want in case something bad happened to you. So let's take a look at these forms. I know you can see it very well, so make it bigger. No, that's not good. So these you can download from the website. You see, this is a HIPAA form. What you disclose, marital health records, communicate, disease, HIV and AIDS, alcoholic drug abuse. So you obviously you don't want people to know anything about that. So you give permission what to disclose. And this is a durable power of attorney sample form. Same thing. I mean, it's like probably more than one page. I just like print out the first page, but you can download one and take a look and see what it pertains, like what you need to write out in order to provide permission. Okay. And let's talk a little bit about estate tax. So there are 3 different types of federal tax: estate tax, gift tax, and generation skipping tax, GST tax. The exclusion amount is like ginormous now. It's like 11.58 million for 2020. And for married file joint is 23.16, so double that amount. And if you calculate the annual exemption credit, it's amount to over $4 million. So you're talking about like the super rich people. I mean, like most of us probably, might not apply, but this is the exclusion rate on the federal level. The maximum federal estate tax rate is 40%. So after, this exclusion amount, there's also 12 different estate tax brackets. So, all these like little bend points, there are 12 bend points, and it ranges from 18% to 40%. And you need to file a form called Form 706. If somebody passed, you need to file it within 9 months after that person passed away. Let me show you how, over the years, the exemption amount, how it changes from $600-something thousand. Okay, max top tax rate is 55%. It keeps going up, keep going up higher and higher and higher. And then in 2021 is 11.7 million, and max tax rate is 40%. So It's like, I'm not going to be paying my estate tax to the federal government because I really don't have that big of an estate, right? But I think in 2025, it will revert back to $5 million. So maybe more people would fall into that category and you need to start planning. And this is like after the exemption, the exclusion. These are the 12 level, how you pay. This is just crazy. So a lot of math, a lot of calculations. And also 17 states has a state tax. Okay, so all right, so let's say I don't have to worry about the federal estate tax, but what about the states? Doesn't care. My own rules. So there are 17 states that say I am going to collect state estate tax, and here are the 17 states. Now it ranges from like 3.3%, 0.8%. to 12 to 20%. So can be high, 20% can be quite a lot. And then there's some exemption, they're high and low. And then there's like inheritance tax too, okay? So some charge estate tax, some charge inheritance tax. So what's the difference? Estate tax is paid by the estate. All right, so the donors, whatever the amount, the money, the assets from the donor, from the person who passed away. The inheritance is like the person who received the money pays it. And then you look at Maryland, you need to pay both the estate tax, state estate tax, and the inheritance tax. So that's probably very expensive. And it gets even more complicated. So who is going to be taxed? So most of the time, if it's a spouse, you're exempt. New Jersey, all but spouse, children and grandchildren. So unless you're a family member, not a family member, then you have to pay the inheritance tax. So, okay, so even though it's like $11 million, like federal exemption, some of the state exemptions is not that high. $1 million, you can start paying, yeah? And here, this is all these colors, the states that has colors, you have to pay either state estate tax or inheritance tax. So how about New York? New York has the highest exemption, $5.9 million. Hawaii has the highest estate tax, 20%. That one's pretty high. 12 state has estate tax and six has inheritance tax. Maryland has both. So you need to be careful. It's not just federal estate tax, but state estate tax too, and inheritance tax that you might have to pay. Gift tax. It has the same lifetime gift exemption of 11.58. And maximum gift tax is 40%. It's imposed on the donor, so the donor pay, all right? And then this is the annual gift exemption. So if you want to gift a gift to somebody, so long as like $15,000 and under, you don't have to report. So if I have a business or I have an asset that I want to give to somebody, so normally I would have to pay gift tax. But so long as every year I don't give more than 15,000, I'll be fine. Generation skipping tax, that means that you give the money to somebody who's more than one generation below you. If it's unrelated, it's 37.5 years younger. So one generation is maybe they think it's about 37.5 years. Maybe it's correct. You know, you get married about around 30, so 37.5. And generation skipping tax is also max transfer tax is 40%. And exemptions are the same too, 11.58 for individual, 23.16 for married filed joint. And then you file the 709 gift tax return. Same thing. I'm going to skip that. This is more complicated, estate planning for couples. So if you're married, you can always give to your spouse, and it's unlimited transfer without having to pay any taxes. Now that's assuming that you are a U.S. citizen. And if you're not a U.S. citizen, it's not the same, okay? So husband and wife, so long as like you're a U.S. citizen, it's unlimited transfer. No tax limits, no tax. But if you are a non-U.S. citizen, then you have to put the money in the Q dot. Okay, so let's see how it works. So for a non-citizen, if you marry somebody who is not U.S. citizen, then the annual gifting is limited to only $157,000. Remember, if it's spouse, it's unlimited. So if it's a non-citizen spouse, then it's only $157,000. And then remember, the exclusion amount is 11.58, but if it's non-citizen spouse, it's only 60,000. But you can circumvent this by putting the money into a Q dot, then that'll be okay. So that's how you get your unlimited deduction. Oh, somebody's. Oh, I see. Sarah already answered. Okay, good. And this is just a chart showing you, if you're a citizen, it's unlimited. Applicable exclusion 11.5 million. So if you want to set up a Q dot, these are the requirements. You need a trustee. So at least the trustee has to be like a U.S. citizen or domestic corporation. And it has to be irrevocable. And you had to do it within 9 months from the date of the death. And then you don't have to pay estate taxes. That's it. Now we want to talk about marital trust. There are many different ones. So I'm just going to skip over and just talk about marital trust, a trust, and the qualified terminal interest property trust. All this is very, very complex. You might, I don't know if anybody has some experience about the AB trust. Okay, so the best way to look at it is use an example. So this is the decedent. Okay, let's say, just make it simple. Okay, so husband and wife, so each has a net worth of $4 million. But let's assume the exemption rules are so it's like 5 million federal tax exemption. So it's not 4, it's 5 million. So if John died, the husband died, if I leave $4 million to my wife, okay, because it's unlimited transfer, right? So 4 plus 4 is 8. So she'll get her and my part. So John and Sue together will be 8. So, but when Sue passes away, it's gonna be more than the $5 million, right? So 3 million would be taxed. So what can we do to avoid paying that $3 million in federal estate tax? So what you do is okay, so what John would do is establish a bypass trust for Sue. But the way it's done is that Sue doesn't own this trust. She only gets the income to this trust. So when she passed away, when she passed away, she doesn't get the 4 plus 4 is 8. So she doesn't get this, and it will pass to the beneficiary. That's how you get by without having to pay estate tax to the government. So we call the whatever that you give to the wife, unlimited is the A trust. What you want to designate for the family is the B trust or the Q-tip. So this is a Q-tip. See, I think all these words are so hard to understand. It's basically you set up another trust, and then the wife only gets the income, and it's not in her estate because it's here, all right? And then when she passed away, you know, it goes to the beneficiary. And this is only 4 and this is 4. So that's how it works. This is about, so if you have unused exemption, the spouse can inherit. And I'm not going to go too deep into it. It's very complex again. And here are some more advanced wealth transfer strategies. And all this is basically taking advantage of like the gift exemption, valuation discount, and how you freeze a gift value by giving it today. And then some of the gifts you get income, like these, you get income. So when you pass, then it will give to the charity or the beneficiary that you want. And because you're receiving income, you're able to discount the gift. And because you give it today, you can establish and freeze the value today. So these are like advanced strategies to how to get your assets off your estate at a good price. And then take advantage and also get some income so you can live on. So you can, and then with like closely held business, because it's not easy to transact or get a fair market value. So a lot of time you can apply discount. So let's say if it's $1 million, a lot of times you can easily discount 20 to 30%. So, and then it's worth less. And you can remove it from your estate. So all this is pretty complex. So I just want to just like mention it, but I'm not going to cover it. All this is, you know, just like any one of this probably going to take half an hour just to explain. So grantor retain the income. I mean, basically talking about these. The grantor will retain the income of the trust, and then when it passes, you know, when he pass, the asset will go to the beneficiary. And then you freeze the appreciating asset at today's price. And then the payment is done on an interest rate. It's established by the AFR, some type of federal rate. It's very, very low. And you pay the interest, let's say it's like 0.1 something percent, it's like 1%, is very low. So on the estate, and you discount the estate using this interest rate and figure out what's worth. It's pretty complex. So these are just other things you can use to plan your estate. I just want to mention one last one, which is the irrevocable life insurance trust. A lot of times people use it to pay for estate tax. And how it's done is that the donor or the grantor will pay the premium, a gift premium, into the trust, and then the beneficiary has the right to withdraw the payment, but the beneficiary will not withdraw it and let it expire, and basically giving up the right. So the trust can use the money that the donor put into the trust and use it to pay the insurance policy. So when the grantor passed away, let's say the insurance is fully funded, so it's not in the estate, so you don't have to pay estate tax, and because of life insurance, you don't even have to pay income tax. So it's a great way to fund estate tax. And then some people would give money to a charitable trust, and you get deductions. Donor advised fund up to 60% of your AGI. Long-term capital gain property, 30%. These are the max that you can deduct, 30% of AGI. And if you give it to private foundation, 20% of AGI. And you can carry the excess let's say you can deduct everything in 1 year, you have 5 years succeeding taxable years to deduct. But it cannot be more than 50% of your HEI. All right, so and the CARES Act kind of like limit the deduction limits, and then it just like you can so long as like no limit to the deductions, you can take the max. These are these limits. And then even if you don't itemize, you can deduct up to $300. All right, so sorry, but this is like really complex. So it's kind of like very difficult. So you probably, if you have like a lot of money, it'd be very advisable for you to consult an expert. Okay, here, let's just do something fun, okay? Because all this is so complex. So let's just like, watch a video. Where is it? Yeah. Let's watch Getting Married. Buying a car. Here, all right, here, this one. No. Share this. Share. Can you see this? I'm gonna play this.
Getting married.
Did you propose?
Yes. Yes, I did.
What did she say?
She didn't say anything, but all friends said, marry him.
And she took my ring.
Whoa! When is that big day? I take it that I'm going to be your best man?
Angelo, there won't be anyone but you. Only if you promise to introduce your girlfriend, Rachel.
I know it. You want to meet her. If all goes well, we might even have a joint wedding together.
Not so sure about it.
Do you know how much a wedding costs?
How much does a wedding cost, everybody? Do you know? How much
A
is
lot. 50
lot.
grand, 100 grand.
33.
33, okay, yes, 33. And that's only average, okay? In New York City, it can be 76,944. Wow, okay? And it doesn't even include honeymoon, so it's even more.
Don't know. Don't care. So long as I can marry my favorite girl.
You are a New York resident. It is a common law property state. Do you know what that means?
What does that mean? Common law property state. 50-50 titling, which one? 50-50 titling. Do you co-own it or whoever's name on it owns it?
50-50.
50-50. All right, let's see. Is it 50-50? Ah, no. In New York, it's actually whoever's title owns it, okay? In California, where it's community property, then it doesn't matter. It's 50-50.
I don't think it matters. I would happily give her 50% of everything I own. And whatever is hers to keep so long as she agrees to marry me.
How nice.
How about you, Angelo? I know you inherited a huge sum of money from your uncle. Are you going to share that with Rachel when you guys get married? California is a community property state.
How about inheritance? 50-50?
No.
Yeah? No.
No, I don't think so.
I don't think so. Yeah, it's my money. No, not gifting. Okay. So that's great.
You don't have to share gifts from inheritance when you get married. Anyway, she has no idea that I come from a really well-off family. I borrow her Netflix account, walk to work, and even work part-time at her college. Yeah, I know. You want to get super close to her so you can stop all her potential suitors. Proximity helps, okay?
Now, I really want to meet Rachel. I'm going to ask my fiance, Tina, to invite her to her bachelorette party.
Okay, let's have dinner together this Friday to talk more.
You mean you, me, Tina, and Rachel?
Of course. And we'll pick a really cheap restaurant.
OMG. Not that same Chinese takeout place, please.
But it tastes good.
The end.
All right, more questions. So when you're married, what are the things you need to remember to do? Open a joint account with your spouse. Change the beneficiary of your life insurance contract. Put her name there. Change the beneficiary of your 401k account to your spouse. Which one?
All of them?
None of the above.
The above. This you must. These I don't care. All right. This, if you married, it's whether you like it or not. Okay. The beneficiary of your 401k account goes to your spouse, and your spouse has to do the same thing. So it's only fair. Okay, these are nice to have, but you don't have to. This is required by law that has to go to your spouse. Okay. We talk about this. I know. Do you remember what is a joint tenant in common? Who gets the property when one tenant passes away? The beneficiary of the tenant passes away, or the other joint tenant? What is it?
First one.
First one?
Mhm.
Tenant in common.
Beneficiary.
Situation when two or more people have ownership interest in the covenant. Each owner has the right to leave his share of property to any beneficiary upon the owner's death. All right, so it doesn't go to the other person. Joint tenancy with right of survivorship. How about that? Who gets the property when one of the co-owner passes away?
The other co-owner.
The other co-owner. Super. All right. So that's great. All right. So you should do a wedding budget. So you see why it's so important. Like when you get married and you understand, the ownership of the assets, like what you want to share, what you don't want to share. I mean, forget about passing away. But when you get married, all those things also come into play. How much is the cost of the wedding? This is just a fun sharing. All right, so that's it for today, and it's that's it. That's all I have. If you want, you can watch. We have the other. We can watch the other. A little bit of time. We can watch the. Let's see the other video. You want to watch the estate planning video?
Sure.
All right, so
Yes.
let's take a look. It's easier. Let's see. Let me see this here. It's more fun. All right, so video. Cancel.
Planning your estate is about caring for your loved ones, seeing they are provided for, and making sure your hard-earned property is distributed according to your wishes. Proper planning now can minimize taxes and confusion in the future. Your estate consists of all your property, including your home and other real estate, tangible personal property such as cars and furniture, and intangible property like life insurance, bank accounts, stocks, pension, and Social Security benefits. You need to be concerned about how your assets are distributed after settling debts to the IRS and paying off your mortgages. When done right, it can ease a lot of strain and avoid family squabbles. Other advantages include providing enough money to support your immediate family. Couples want to provide enough money for their surviving spouse. Couples with children want to secure their education and upbringing. For children under 18, both you and your spouse should nominate guardians for the children in your wills, in case both of you die before they grow up. Otherwise, a judge will decide, without your input, where your kids will live and who makes important decisions about their money, education, and way of life. Speed up the transfer of your property to beneficiaries. Options include insurance paid directly to beneficiaries, joint tenancy, and living trusts. In addition, you can use simplified or expedited probate and taking advantage of laws that provide partial payments to beneficiaries while a will is in probate. Plan for possible mental or physical incapacity. Living wills and durable healthcare powers of attorney enable you to decide in advance about life support and pick someone to make medical decisions when you are incapacitated. Other advantages include minimize transfer expenses. Good estate planning can keep the cost of transferring property to beneficiaries as low as possible, leaving more money for your beneficiaries. Reduce estate taxes. Your estate must pay estate or inheritance taxes on every dollar in the estate. This is a dollar that your beneficiaries won't get. A good estate plan can give the maximum allowed by law to your beneficiaries and the minimum to the government. Ease the strain on your family. Take the burden from your grieving survivors by planning your funeral arrangements when planning your estate. Choose competent executors. Giving executors and trustees the necessary authority will save money, reduce the burden on your survivors, and simplify administration of your estate. Or help a favorite cause. Your estate plan can help support religious, educational, and other charitable causes, either during your lifetime or upon your death. And at the same time, take advantage of tax laws designed to encourage private philanthropy. Provide for people who need help and guidance. Do you have an elderly parent or disabled child, or a grandchild whose education you want to assure? Support them with a special trust to fund the necessary support when you are no longer around. Business owners can ensure business continuity. If you have a small business, you can provide for an orderly succession and continuation of its affairs by spelling out what will happen to your interest in the business when you are gone. Everyone should have a will, but do you know less than 50% have one? If you die without a will or trust, we say you die intestate. The state will decide how to distribute your assets. New York intestate rules. If you have loved ones you want to take care of, they might not get the money depending on how the state decides on distribution priority. This is how assets are distributed in New York if you die intestate. Let's do an estate plan. There are some key pieces of information required when creating your estate plan. Make a list of the contact and birth date information of all people in your will, contact info of executor and guardian, your income sources, including interest and dividends, financial assets, like your savings, checking, retirement, and brokerage accounts, your debt, mortgages, installment loans, credit cards, and business debts, if any, personal property, such as jewelry, antiques, and real estate, jointly owned property and the names of co-owners, important legal documents, such as prenuptial agreements, marriage certificates, divorce decrees, recent tax returns, existing wills and trust documents, and property deeds, and the location and content of safe deposit boxes. Stuff that you need to gather. When you have a will, it needs to be validated by the court. This process is called probate. The court will appraise and inventory all assets, then make payments. This only affects probate assets. Assets transferred through trusts and contracts such as 401k and life insurance are outside probate. According to AARP, typical probate costs run about $1,500. It varies from state to state and on size or whether the will is contested. Most states have adopted probate alternatives for estates with no real property or assets under $50,000. typical probate time is 6 to 9 months. A will lets you control the distribution of your property, designate a legal guardian for your children, and choose an executor to handle the distribution of your estate. For the will to be valid, it must be countersigned by 2 witnesses with no potential conflict of interest. If you die without a will, the probate court will appoint an administrator to distribute the property in accordance with the state laws. The costs are more expensive and must be paid out of your estate before any property is distributed. During your lifetime, you can move your assets into a revocable living trust to be transferred to your beneficiaries when you die without going through probate. Most people name themselves as trustees to control assets during lifetime. In addition, you can also add a successor trustee to take care of the trust when you pass away or become incapacitated. Benefits of this type of trust are: it's revocable, it's private, and can be used in case of incapacitation. You'll still need a will to cover any assets that have not been transferred to the trust. Revocable living trusts. Drawbacks for this type of trust are: assets not protected from creditors, grantor is subject to income taxes on income earned by trust, and it can't avoid estate tax. Irrevocable trusts also allow transfer of assets outside of probate. This trust can't be dissolved or changed once created. Gift tax due on property transferred. Once property is transferred, assets cannot be removed. And you cannot change beneficiaries or rewrite terms of the trust. Although there are many restrictions, the benefits may be worth it. After transferring assets, the grantor has given up ownership of the property and any future appreciation. This means reduced estate tax liability, resulting in more being passed to beneficiaries. Assets left to your spouse, U.S. citizen, or charitable organization are not subject to estate tax. Gifts under the lifetime gift exemption of $5.45 million in 2016 are not taxed. Anything above this is taxed at 40%. Annual gift tax exclusion is $14,000 per person per year. There is no tax on the $14,000, and it doesn't count toward your lifetime gift exemption. Direct payment of college tuition and medical bills are free of gift tax if paid directly to the institution. Watch out for generation skipping tax transferring to someone more than 37.5 years younger than donor, state taxes. Also, be aware of income, capital gains, and property taxes. Proper titling of assets can assist in asset transfer, avoid probate and estate taxes. Title of assets after marriage depends on where you reside. In community property states, all property earned or acquired after marriage is co-owned 50-50 by the couple. In common law or non-community property states, ownership is separate, dependent on titling. An exception to this are properties acquired through inheritance or gifting. These stay separate. Tenants in common. If one co-tenant, co-owner dies, that co-tenant's interest in the property would pass to the beneficiary named in his or her will. This would apply to co-tenants who are married or in a domestic partnership, as well as to those who are single. Joint tenancy with right of survivorship. Co-owners of a property can also hold title as joint tenants with right of survivorship. If one tenant were to die, the property would simply pass to the surviving joint tenant without probate or being affected by the deceased person's will. Community property with right of survivorship. You and your spouse or partner can hold title to property as community property with right of survivorship. Then, if your spouse or partner were to die, the property would pass to you without being affected by the deceased person's will or probate. Before you become incapacitated or incompetent, you want to prepare a general power of attorney to designate someone to handle your finances. Also prepare advanced directives to provide instructions on how to handle your end-of-life healthcare options. Typical powers of a general power of attorney allow the agent to handle all of the principal's affairs during a period of time when the principal is unable to do so. Typical powers include banking transactions, buying and selling personal property, purchasing insurance, performing transactions involving securities, settling claims, getting into contracts, filing tax returns, handling government benefits. Additional powers that can be assigned include maintaining and operating a business, employing professional assistants, making gifts, making transfers to trusts. Power of attorney must be signed by the person granting the authority. In addition, the principal must be mentally competent at the time of signing to make it legally binding and should be notarized to prevent challenges. A durable power of attorney means that if the principal becomes mentally incompetent while a power of attorney is in effect, a durability provision will allow the document to stay in effect. Advanced directives are needed when you are no longer able to make decisions for your own healthcare. Healthcare power of attorney, a document that allows the principal to designate an agent to make healthcare decisions on his or her behalf if he or she is unconscious or mentally incompetent. Living will allows the individual an opportunity to officially state the type of care he or she would choose when facing terminal illness and can't communicate with his or her physician. Normally used to outline pain management and life support treatment. Don't wait until you're sick. Do it now when you're healthy. Give a copy to your physician, your healthcare agent. Keep a copy in your files. Give a copy to your relatives and your closest friends. Thank you for watching the Financial Wellness Tower Estate Plan video. To continue your education on financial wellness, go to Pension Maxima's Financial...
All right, so I just want to show you because that site has a lot of videos. Let me just show you. So you see, I mean, like you guys have the lock-in power to this. So didn't really show you what's in here, but it's got like 18 to 19 videos of the main topics, and a lot of we watched together. Oh my God, it doesn't move. It's so slow. And it's got a quiz and a workbook. So if you want to continue learning, it's got like these links for you to, oh my God, it's just not working very well. Check out the site, and they're like trivia and their budgeting quiz and they're like cartoons. There are a lot of things there on the Financial Wellness Tower site. And if you, yes, see. Okay, these are module 1, watch and learn, and then module 2, like you remember, like we watch Getting Married. That is like under module 2, the interactive videos, and it will stop nasty questions. And the other trivia, life game, budget quiz. So there's like a lot of stuff that you can benefit. Like let me just show you here. And then the interesting thing is, like, I don't know if you guys like speak another language. The videos are available in 3 languages, English, Chinese, and Spanish. So let's say if I go on financial budgeting, okay, let's say financial budgeting. I can pick, if you want to test your Spanish, let's say you pick Spanish. Is it Spanish? I don't think it's still not Spanish yet. Okay, and then you can listen the whole thing.
¿Te sientes abrumado por tus responsabilidades financieras? Tal vez hayas renunciado a la esperanza y no encuentras la manera de salir. Este video de presupuesto financiero.
So if you want to listen to Chinese, all right, it's the same thing. Let's listen to Chinese.
您是否觉得自己快被财务责任压垮了？也许你已经放弃了希望，觉得没有出路。这个财务预算视频将告诉你。
And here, let's go back to English. So there's a quiz. So you're gonna ask, make sure after you watch a video, you can do the quiz, and you start the quiz. How many credit bureaus are there? Yeah, you know, all right. And then there's a workbook. to give you more learning. It takes too long to quiz, but you can go in and do all that. So for all these topics, all right. So, I mean, continue to learn. So this is, okay, here, there we go. Credit scores influence the credit that's available to you and the terms. When you apply for credit, all right, so, and this is a credit report, Equifax data. So you get it? So you can go in and mark complete when you're done. So there's like a lot of information, but I thought this is like a backup, you know. I think it's also very important to be able to communicate and share what you've learned, and also have somebody, I mean, like, you know, have Sarah to talk. I mean, she's the expert in Eldercare. I mean, it's always good to have somebody who's in that field, been working, you know, every day, to bring us the fresh knowledge of that topic. So that's all I have, and really thank you so much for joining the class. And if you have comments, you know, really welcome. You know, I think it's like process is always like learning and try to be better. And this is the first time we teaching this class, so obviously there's like a lot more to learn. So tell me how we can improve this. What can we do? And I'll be very open.
Good. It was very good, Bonnie.
Thank you very much, Bonnie.
Yeah. So if you have problems signing in, okay, let me know. Because there's also games too. I mean, like, and then they're like, I don't know if you've seen that, they're like cartoons too. I'm gonna send you guys cartoons.
Mm-hmm.
Have you? They're cartoons which, I mean, I'm not gonna. It's too much, but they're cartoons which is like really fun on all these topics like budgeting and then really silly topics. So you get bored and you don't want to do real work, you can just enjoy yourself. I mean, the whole point of it, I think learning has to be fun. Otherwise, like, what's the whole point?
Yeah.
All right, so we're gonna have this again. You know, I think Jim was talking about, we're gonna keep running this. Maybe we're gonna have another one in spring. So if you know anybody who's interested in learning, you know, please refer that person to our class. And maybe we can give out a coupon or something. We have to talk about. We haven't like, really like talk about in detail, but like we want to keep it going. And then the topic I was thinking is going to be like, we have 10 classes, but I'm probably going to pull a few out. And then, you know, I think like life insurance annuity might be pretty important, but we'll keep the basics, the more important ones like the budgeting, debt management, you know, the key ones there. And then other ones, maybe we'll add a few different ones just to vary it once in a while. Okay, so that's all I have. It's 7:30, so thank you so much. And please remember to do the review and share comments on how we can make this class better, because I think like a lot of people need it, and you guys are the first one who benefit. So really want to learn what you've learned, and so help us improve this more. Okay, so thank you.
Thank you.
Okay.
Thank you, Penny.
Bonnie, thank you very much.
Oh, you're very welcome. Bye-bye.
Yeah.
Take care. Bye-bye.
Session too.
Bye-bye.
Jim, thank you.
Yeah.
Bye, Jim.
Thanks, Patrick. Have a nice Thanksgiving.
You too. Enjoy.
Thank you.
Bye-bye. Thank you.
Bye, Mike.
All right. Keep in touch. Bye.